So Kat's question, I think, is kind of home run. Say it again a little bit louder.
Would discrimination against gender identity or expression fall under sex discrimination?
Okay, and the answer is we don't know because the courts have been all over the place on this. If one were to look at the precedent from the Price-Waterhouse decision, one would say yes. But some students that would like to have trans restroom access have said that is an issue that is not about sexuality but is about gender. Can that count as an act of my school district discriminating against my sex? And the answer has not been clear yet from the courts. The affirmative would maybe try to clear that up by having the court make that ruling. Go ahead. Yeah?
Why would they have to use Title IX as justification instead of just like the 14th Amendment?
Why would they have to use Title IX as a justification instead of the 14th Amendment? We'll talk about that a little bit more, but the answer is that the more you use Title IX, the more you can begin to set precedents in other areas of the law. And there are some interesting advantage areas that strategically the affirmative might want to utilize. All right, now we're moving. Go ahead, last one.
So, just theoretically, if someone went through gender reassignment surgery,
okay,
would then because then they are classified as a different gender, what would the school do in that case? Because
okay, so this is a great question, and it's immediately relevant. The question that was put on the table is what happens when you have gender reassignment surgery, okay? Well, Gavin Grimm has had certain anatomical surgeries, and Gavin Grimm not only identifies gender as male, but even could make an argument that there have been anatomical changes. But a lot of these school policies say sex assigned at birth. And so that has created a complicated issue, all right, because sex assigned at birth is obviously different than gender reassignment.
But if it's changed on your birth certificate and they can't see the original copy, that's
Right.
an adoption.
Right. Well, you're not, so you're lawyering this whole situation, I understand. But trust me when I say that Gavin Grimm has struggled to use the bathroom of his choice. Okay, do you want to go or you got it?
Yeah, so you said most of the complaints come not from the students themselves, but from the parents and learners.
Statistics reveal that more of the complaints have tended to come from parents than peers.
So I find that curious because the question transgender students. Okay, so what is their opinion on the matter, not the parents?
What is the opinion of trans students?
You had three options. Which one was there?
There's no one answer, I suppose, all right, because there are lots of trans students. But by and large, I think that the policy that would at least afford the option of using the restroom of one's choice is the one that I would strongly suspect, on balance, trans students would prefer. Now obviously, you're dealing with hundreds of thousands of students, you know what I mean? So there could be a diversity of perspective there. But on balance, I think the people that study this think that that notion of choice would be more popular. All right, let's keep going, although we're getting great questions. Oh no. Uh-oh. Things have happened. Hayden, can I get you again? What's that? I don't have anything here. I have no...
Oh, you got no screen?
Yeah.
Oh, weird.
All right. Well, it's going up there, so at a minimum, that's good.
Yes.
Okay. All right. So Title IX, that you'll see that in your packet. That's Roman numeral. You just pronounce it Title IX. Says that schools cannot receive federal funds if they engage in sex discrimination. Gavin Grimm filed a lawsuit, and Gavin Grimm won in federal court because the gender discrimination that was occurring was deemed by the Fourth Circuit Court, in part, to be an act of discrimination. A little more complicated than that. But one of the issues that the Supreme Court could resolve is whether or not the word or phrase sex discrimination extends beyond sex assigned at birth. So the affirmative would say that sex discrimination does apply to broader notions of gender, and the negative might say it doesn't. Go ahead, loud.
Yeah, so under Title IX, if
Yeah.
Title IX only takes away federal funding if there's sex discrimination, does it not make it legal? So they just lose federal funding?
I suppose a school district could say that we will just kind of live without federal funding, but they would also be prone to what's called a civil lawsuit. So even though they wouldn't be against a criminal law, they could also get sued and lose a lot of money in addition to not getting federal funding. Yes? Private schools would not be affected by Title IX, but there might be social pressure and social norms as they change. But yes, private schools could be a loophole for this. Yeah.
Is there like some sort of potential problem by realistically connecting sex to gender?
So the question is a great one. Is there a problem legally connecting sex to gender? And there's a lot of people that worry about saying that they're the same or that they overlap. Liberals and conservatives alike have critiques of the idea of making sex and gender be synonymous. So those are some clever arguments that the negative could advance. All right, I'm a little bit behind, so I'm going to keep moving. All right, this is the concept that I kind of teased as the most difficult to understand. Who is that? Does anyone know? That's Neil Gorsuch, the most recently confirmed Supreme Court nominee, and Neil Gorsuch rather famously does not like what's called judicial deference. So, another hypothetical, you read it and put yourself in the mindset of the teacher. What might the teacher do in this hypothetical? I'll give everyone a second to read it. How long was your lunch break? An hour and a half. All right. We'll go up to the top here because we haven't called on yet. Here. Start there with glasses. Go ahead. I think my students could learn better. We're experts. We know that early lunch helps. All right, another one right here. Go ahead. They could organize. All right, that's extreme. Yeah. Last one here. Yeah. Loud. All right. So this analogy was very intentionally chosen because it plays out inside the federal government every day. Not the specific instance of when your lunch break will be, all right? But more in this sense. As I think most of you know, there are 3 branches of government. And I'm going to talk a little bit about the executive branch. The executive branch is filled with a lot of agencies. All right? I drew an example of some agencies before, like the Environmental Protection Agency, or the Department of Education. And these agencies have the ability to change policy. Technically, under the Constitution, large changes in policy need to be confirmed by all three branches. But agencies have kind of created an end around where if something can't get through the Congress, agencies, which are part of the executive branch, can still make the change. This is especially important because, as you may or may not know, it's very hard to get any big change through Congress. Raise your hand if you've heard of the filibuster before. Okay, most of you have. The filibuster is a procedural move in the United States Senate that basically makes it so that for most items it is impossible to pass it through the Senate unless you get 60 votes. But the current president doesn't have 60 votes. There are 52 Republicans of the 100 in the U.S. Senate. And for 6 of Obama's 8 years in office, President Obama also did not have 60 votes. And so the filibuster is used all the time, either by Democrats that would like to oppose Donald Trump's agenda, or by Republicans that wanted to oppose former President Obama's agenda. So what happens is, in the same way the teachers in the example pulled an end around, the presidents, both Obama and Trump, have started to pull an end around of their own. President Obama knew that he would like to increase trans restroom access. He also was positive that that would never pass the United States Senate. And so, President Obama's Department of Education released something that was called a guidance letter. I'll say that again, a guidance letter. And the Department of Education said that they understood sex discrimination to mean forms of discrimination that did not allow people to use the bathroom that corresponded with their gender identity. This never would have passed the Congress because he never could have gotten 60 votes for it. And so they used the agency to get it to pass. The problem is that when you use an agency to get it to pass, people can challenge you in federal court, just like the students and parents can challenge the teacher's decision about lunch. Citizens in the United States can challenge the Obama administration's understanding of sex discrimination. And they did. And the Fourth Circuit heard a case about Gavin Grimm when the Obama administration was still the president. And part of the rationale for the Fourth Circuit Court in Virginia was, we think sex discrimination includes gender discrimination on trans restroom access because the Obama administration is an expert, because their Department of Education knows more about education than we do. And so in the same way that the principal in the analogy deferred to the wisdom of the teachers, here the Obama administration received deference from the courts, and they deferred to the wisdom of the Department of Education when they came to determine that sex discrimination included gender discrimination. So Gavin Grimm wins. It's been determined by a federal court. The Supreme Court says we're going to take this in October of 2016. In October of 2016, And then the Trump administration wins in November of 2016. And what does the Trump administration do with its Department of Education? Does anyone want to hazard a guess? Go ahead. They rescind the guidance letter from Obama. Instead of saying Obama was wrong, and this is important, they said it should be determined by states. And so I just want to kind of almost do like a little bit of a skit for you. Imagine that this computer, all right, is like the most conservative person that you know in your family, all right? All right? And imagine that I'm the most liberal person that you know, all right? When the Obama administration changed the guidance from the Department of Education, this conservative person was like, I hate that agencies have the right to do this and that courts defer to agencies. It's ridiculous. We shouldn't be deferring to agencies. And all these people wrote briefs to the Supreme Court, and they were like, judicial deference is terrible. It's awful. The justice system shouldn't defer to agencies. Agencies shouldn't be allowed to make an end around. It's ridiculous. All right? And then, all right, these people were like, judicial deference is the best. It's so awesome. It's constitutional. We have to allow it. We wouldn't get anything done because Congress is a mess. Why wouldn't we have judicial deference? And then the Trump administration wins, and these people have all these written briefs that are like, judicial deference is terrible, and these people are cheerleading as to how great judicial deference is, and they completely flip. And these people are like, wow, judicial deference wasn't so bad after all. All right? And these people are like, judicial deference, that's against the Constitution. All right? That's ridiculous. All right? It's ridiculous. So, everyone has flip-flopped on this question, and the affirmative is arguing that judicial deference is bad. Okay? The affirmative is arguing that whether it's the Obama administration or the Trump administration, that things just can't pass solely through agencies, and that if we were to make a Supreme Court ruling right now, and that Supreme Court ruling said no more deference, it would hurt the Trump administration, not just on the question of trans restrooms, and not just on the question of states' rights, but on a lot of other agency decisions that are being made by the Trump administration. The Trump administration is using judicial deference to use agencies to change the Environmental Protection Agency, to change trade laws, to change a lot of stuff, because literally nothing passes through the Congress. So if the Trump administration wants to get their agenda, they're going to use agencies to do it. And they're going to rely on the fact that when those agencies get challenged, the justice system will punt on it. And so the affirmative is saying that judicial deference is bad because it would be good to hurt certain aspects of the Trump agenda. That's sort of complicated. That's why Kirby was confused at the beginning. But hopefully it's making some more sense. I'll take a few questions now. Go ahead.
So are things more like solid if they go through Congress than through agencies?
Things are, I don't know what you mean by solid, okay? Because obviously people on both sides don't like certain things. But from a legal perspective, okay, if something passes through the Congress, it's much less likely to lose in the court system. However, judicial deference is pretty strong. In fact, there's a piece of evidence in the opening packet that says about 90% of the time when an agency gets challenged in court, they say that they'll use judicial deference and they win. So it's pretty effective legally to use judicial deference. Right here.
Does context matter in reference to the law? Like in the way that...
Yeah, I don't think that they could say, for instance, that sex discrimination means a skyscraper. Does that make sense? So there are instances where the court says that you have just made something that's called a nonsensical understanding of a term, but the court does that less than 10% of the time. The court defers to the wisdom, in the old analogy, of the teachers, or in this analogy, to the agency 90% of the time. So the Trump administration, which is struggling to get their agenda through Congress, is obviously going to use agencies, and they're going to rely on the fact that the courts aren't going to check the agencies very often. Go ahead.
If the app wants to get rid of deference,
Yes.
Congress can get nothing done, wouldn't the app just roll back other problems?
If the app wants to get deference and Congress can't get anything done, what?
If the app wants to get rid of the deference,
Yeah, they do.
Congress can't get anything done.
Right.
Wouldn't the app just start rolling back problems in the Congress and then nothing would get done?
Nothing would get done. And the affirmative would say that that's good, and the negative could say that that's bad. Yeah. Very little would get done. The Congress does occasionally pass non-controversial things. All right, go ahead.
Quick legal question. So,
Quick legal question. I'll do my best.
no, if a court says I'm going to defer to an agency and
Yeah.
then that agency changes under a new administration,
Yes.
do they defer to the new agency or the old agency? So for example,
The reason the Supreme Court in March said we're not taking the Gavin Grimm case anymore is because it was confusing as to what the agency's stance was, and the reason that Gavin Grimm won in court was because of deference to the Obama administration. So the Supreme Court said, we're sending it back to you, the Fourth Circuit, and you can re-decide this, but it would appear as though Gavin Grimm is very likely to lose because the state of Virginia has, and the localities in Gloucester County have the right, according to the same deference, okay, to do it their way. So, Gavin Grimm was digging judicial deference when Obama was in charge, made all the arguments, all right, in favor of agency discretion, and now those legal arguments work against Gavin Grimm's case, which is why it's in legal limbo.
no, but I understand that, but if it says specifically defer to the Obama administration's X and Z policy.
Right.
And
That doesn't exist anymore.
But that's what I'm saying.
Yeah.
Is it then in effect to the old policy or whatever Trump's new policy is? Like, do they defer to
The
Trump's?
wisdom, the court deferred to the discretion of the agency.
The agency has since changed.
Well, in some ways it's changed, like the people, yes, Betsy DeVos runs it now, okay?
Yeah.
Right? But the court is still sort of stuck with its rationale that it's not their wisdom, it's the agency's wisdom. Does that make sense?
But when the agency changes, is it by the rules? So, because court law has to kind of be set, it can't be, like it's very...
Right, so it's set by deferring to the agency.
But the agencies are fluid, so does that mean that the law is changed? Like Gavin Grimm one day...
It means
can go-
that agency deference no longer helps Gavin Grimm win his case.
But does that mean one day he can go to the male restroom and the next day he can't because the agency has changed overnight? Like, let's say tomorrow the agency says...
It's not exactly one day after another because the court's resolved it, but yes, when Trump won and the court re-entered its verdict, Gavin Grimm went from being able to use the restroom of his choice to not being able to
But
use
if
the
the court
restroom.
hadn't granted their verdict and the agency had just changed, so let's say just the agency
Right.
changes and nothing else changes, and they're deferring to the agency, are they deferring to the old agency?
I don't know how to describe it. I understand that you keep asking this.
Yeah.
They are deferring to the agency's wisdom. When the agency's wisdom changed, Gavin Grimm went from winning to losing. Legally, they're not deferring to the specifics of the policy. They're deferring to the wisdom of the agency.
Okay.
The agency, even if it didn't change administrations, could change its policy and they would still defer to the wisdom of the agency. Does that make sense?
Yeah.
Right, yeah. All right, I gotta keep going. I gotta get one more in. All right. So, Gavin Grimm won under the Obama administration and then lost because it was an issue of states' rights. The last thing I want to do is explain the notion of excessive state flexibility. I think you will understand this advantage more if you view it as an advantage that is not about trans rights. I'll say that again. You'll understand this advantage more if you view it as not an advantage about trans rights. Rather, the affirmative is arguing that because the reasoning of the Trump administration was states can do what they would like, there's an opportunity for states to revisit other civil rights issues unrelated to trans justice. Reasons matter. So when the reason is states' rights or local rights, that's new. And the states might take that flexibility, especially the 32 states that I mentioned before, and revisit other legal battles. And they might win in court, they might lose in court, but they have a new argument at their disposal. And the new argument at their disposal is that the Trump administration said that the Department of Education's rationale should defer to state and local judgment. Okay, I'm very quickly going to explain a little bit of some negative stuff. One of the negative arguments is the social trends argument. We had an example of that when we discussed Canada. There are other examples of how trans consciousness has certainly become more mainstream or more discussed in the last few years. There's a good back and forth on this. In 2014, Time magazine wrote an article. It had Laverne Cox from Orange is the New Black on the cover. The article said that this was the next breakthrough in civil rights. Some people have said that that article was a huge issue of visibility. Other people have said it's been counterproductive because there hasn't been very much breakthrough on trans justice, but that is sort of the back and forth. A little over a year ago, Target stores, like the Target that you know of and have probably shopped at, decided that they were going to allow people to use the restrooms and changing rooms that corresponded with their gender identity. It actually was their policy beforehand, but they made it more public, somewhat inadvertently through an email that got out, and they stood by that policy change. Some people view this episode as a breakthrough to have such a large retailer publicly make a policy of that sort, but the policy has been not warmly received in certain parts of the country. Target stores have seen a sharp decrease in sales. Some people think that that is because of the trans bathroom policy. Some people think it's because of Amazon Prime, which is beside rules. And there's very good evidence on all of that. It's kind of a complicated question as to whether or not Target lost business because of this. But Target did decide in all of its stores south of the Mason-Dixon line, that's pretty telling, in all of its stores south of the Mason-Dixon line, to create a third-party changing room for people that were not comfortable using the male or female changing rooms. There's also weird studies about how Walmart has gained business during this time, although some people don't think that that is entirely related to the trans restroom issue. The last thing I want to talk about is the trans pessimism critique, which you can talk with your instructors about a little bit more later today. But these laws, like the affirmative, which come along and say it is against the law to discriminate against trans people, a lot of people say that those laws don't work, and some of you have given the reasons. It doesn't change society, etc. But there are other more complicated reasons, and Dean Spade writes several, although not all of the cards in the trans pessimism critique. But Dean Spade's argument is sort of interesting and says that the only people that can really benefit from these laws are people who are relatively well off financially. It is intriguing that Juliet Evancho and Gavin Grimm were able to file lawsuits in federal courts, but not everyone comes from that amount of financial resources. And these victories tend to be for individuals, and sometimes Dr. Spade argues that that does not create broader change. Obviously, a ruling that was on equal protection would change the law for everyone in the whole country, but sometimes you see more narrow victories in the law, and there's questions about whether or not that is a successful approach. Okay, so I really want you to be able to have enough time to go back to the residence hall and eat, but I also want to make sure that, you know, you have an opportunity to ask any questions that you might have of me individually. I'll stick around here for 10 minutes and answer any questions that you might want to pose. Just come forward. Please eat lunch with someone you don't know and figure out where your lab room is. Thank you very much.